Donc, bon après-midi et bienvenue à la 5e séance de notre cours bilingue intitulé Transnational Futures of International Labor Law, la justice sociale dans le monde du travail. Ce cours je tiens à reconnaître d'abord nos collègues Pat Thompson et Nora Cole de la Fondation Atkinson qui sont parmi nous, qui sont venus de Toronto pour nous suivre live aujourd'hui. Habituellement, ils nous suivent par le web, donc merci pour cette initiative. Je m'appelle Adele Blackett. Je suis professeure de droit et chaire de recherche du Canada en droit transnational du travail et du développement ici à la faculté de droit de l'Université McGill. J'ai aussi l'honneur d'être lauréate de la Fondation Pierre-Elliott-Trudeau et cette fondation appuie cette initiative commémorative du centenaire de l'Organisation internationale du travail. Permettez-moi de commencer cette session avec une reconnaissance que nous situons sur la terre non cédée de la Confédération Haudenosaunee, une terre qui a aussi servi de lieu de rencontre pour différentes nations autochtones, y compris les peuples Anishinaabe. Si je fais cette reconnaissance de façon systématique, c'est aussi pour nous rappeler que le droit international et le droit transnational du travail enraciné dans la terre et profondément lié au peuple qui y situe. Nous pourrions même affirmer que le droit transnational du travail a trop souvent manqué un rendez-vous historique et contemporain avec les notions de la territorialisation et avec la dépossession des terres. Le travail y est lié. La semaine passée, nous avons abordé les questions historiques et contemporaines liées à la fois au droit du travail maritime et le droit autochtone. Et au-delà des sujets très pertinents abordés sur la construction normative interinstitutionnelle et l'interprétation de ces normes internationales du travail par des instances de droits humains, les questions pertinentes à ces sujets nous permettent de façon assez basique de considérer l'importance de la territorialité à l'application du droit. Les ports maritimes dans un droit autrement non ancré sur la terre en font témoin et la détermination donc en droit maritime via entre autres le droit international privé de la juridiction appropriée est un exemple. Et certainement, en ce qui concerne les droits autochtones, les conflits postcoloniaux sur la terre autochtone et l'interprétation a donné aujourd'hui à une notion comme le droit à la consultation dans le droit international du travail dans le contexte de la Déclaration des Nations unies sur les droits du peuple autochtone est un exemple pertinent, important, sur lequel nous réfléchissons quand nous réfléchissons à l'avenir du droit international du travail. Cette semaine, nous avons l'occasion, à un certain niveau, de prolonger ces réflexions et dans l'approfondissement de cette notion du droit transnational du travail, nous avons la possibilité de considérer le rôle d'acteurs multiples dans la question de l'élaboration, du renouveau aussi du droit international du travail. L'OIT, certainement, par son œuvre normative, mais aussi, et les présentations en feront témoin, la capacité d'autres acteurs, y compris l'OIT, d'agir non seulement via les normes, mais via la présence, via l'utilisation d'espaces que crée une organisation internationale pour interagir avec les corporations nationales, transnationales, les membres de la société civile, les syndicats, les États eux-mêmes sous leur forme plutôt décentrée, différents ministères, différents acteurs gouvernementaux. Nous considérons aussi aujourd'hui les tribunaux, et plus précisément les tribunaux canadiens, qui sont interpellés plutôt à décider des litiges contemporains concernant les actions d'acteurs corporatifs à l'extérieur de leur territoire. Et surtout, nous considérons le rôle des travailleurs et des travailleuses dans ce contexte. La tragédie de Rana Plaza, où 1133 personnes ont perdu la vie au Bangladesh, est un moment qui est devenu paradigmatique d'une responsabilité sociale, corporative en devenir, une situation qui expose les profondes limites et certaines possibilités. Donc aujourd'hui, nous aurons l'occasion de réfléchir sur ce que une situation comme cela nous offre comme possibilité de réfléchir au droit international du travail et ses aspects transnationaux. Nous avons donc la possibilité de se demander comment ébranler, voire supplanter une approche au droit du travail devenue la norme pour imaginer une autre façon de concevoir l'action normative en droit du travail, une action plus durable éventuellement, probablement multiforme, une action qui conserve le rôle d'acteur traditionnel et qui en rajoute d'autres. Donc, il y aura de quoi réfléchir aujourd'hui sur un droit transnational du travail en mouvance. J'ai l'énorme plaisir aujourd'hui de présenter donc des acteurs qui sont profondément ancrés dans les développements qui se passent et qui ont une expertise hors pair sur ces questions. Il y a 2 semaines, le professeur émérite Evans Kalula, qui nous a adressé par visioconférence, a offert un témoignage concernant la première personne qui va vous adresser, Anne Treblecock. Evans Kalula a souligné le privilège qu'il a eu d'avoir eu comme mentor Anne Treblecock quand il est allé à l'OIT pour la première fois. Et il a mentionné que moi-même, j'ai eu ce même privilège. Et donc, c'est un énorme plaisir aujourd'hui de pouvoir accueillir Madame Anne Treblecock parmi nous. Anne Treblecock is the former legal advisor and director of legal services at the International Labor Organization's Permanent Secretariat in Geneva, where her career spanned almost 25 years and addressed issues of public international law, international labor standards, comparative labor law, and fundamental principles and rights at work. Since retiring from the ILO in 2008, Anne Treblecock has served as a neutral in dispute resolution for the European Bank for Reconstruction and Development, the International Federation of the Red Cross and Red Crescent Societies, the Gavi Alliance, and she's currently a member of the Asian Development Bank's Administrative Tribunal. She's on the advisory board of our own Labor Law and Development Research Laboratory here at McGill, and of the International Labor Rights Case Law Journal. She has co-edited a Manuel du droit international social, 2012, a research handbook on transnational labor law from 2015, and she's authored and edited the research collection on comparative labor law published in 2018. She's also published widely on a range of contemporary issues of concern, including labor market informality and the role of the ILO, so in articles, book chapters, and she's taught courses here at McGill University, where she taught international labor law, and at the universities of Detroit, Gabin, Göttingen, Hanover, and San Diego. The title of her presentation today is Rana Plaza, 5 Years On, corporate social responsibility and transnational labor law. And Treblecock, thank you very much for coming.
Bonjour tout le monde. Merci bien à Professeur Blackett, aussi à la faculté de droit de McGill, au laboratoire et à la Fondation Trudeau de m'avoir donné l'occasion de participer dans ce dialogue qui aborde des thèmes à la fois très actuels et d'une importance capitale. C'est un grand honneur d'être parmi vous. Quoique je continuerai en anglais, je vous encourage de poser des questions, soit en français, soit en anglais. But first, a quick disclaimer. I'm speaking solely in my personal capacity here. As Professor Blackett mentioned, the Rana Plaza disaster in Bangladesh marked a turning point, a watershed for corporate social responsibility. Or did it? As we trace what has happened since it occurred, we can ask what the implications might be for transnational labor law. In April 2013, 1,133 people lost their lives when a building that housed 5 factories near Dhaka in Bangladesh collapsed. 2,500 more were injured. Oops. The garment workers who were trapped inside here had been manufacturing clothing for a range of foreign brands through a series of deals with suppliers and subcontractors. In the wake of the world's worst industrial disaster to date, 2 strains have emerged. The first entailed innovations that responded specifically to the situation in Bangladesh, which is the world's 2nd largest ready-made garment producer. The second involved evolution in wider processes that were already going on, but were informed by the Rana Plaza experience. As the International Labor Organization marks its 100th year, and as global warming accelerates, it is a timely moment for reflection about how to change unsustainable patterns of production and consumption that can lead to such disasters. We see a tension between a quest for greater accountability along an entire value chain and encouragement of business models that precisely aim to limit this. There are several regulatory dilemmas lurking in the background. The first is that an international legal instrument that is agreed by states can bind them directly, but enterprises only indirectly. Another is that when a state tries to act on its own, it may confront challenges of extraterritoriality and accusations of meddling in others' domestic policies. Given emerging geopolitical realities, the latter refrain is one we are likely to hear more often. Then there is the debate over the merits of so-called hard and soft law, and the continuing search for the optimal mix. So even as we track innovations that have followed Rana Plaza, we should bear in mind that what has been achieved so far should not be taken for granted. Transnational labor law has its origins in the struggles of social movements and involves an interplay between public and private orderings that is also evident in this case. The immediate responses to the situation in Bangladesh involved initially what are known as the Accord, the Alliance, and the Arrangement. Right after the Rana Plaza event, the 2 main global trade union federations and 40 global garment buyers asked the ILO to help them negotiate an agreement that became known as the Bangladesh Accord. An ILO mission took place days after the tragedy to smooth dialogue among government, employers, workers, development partners, and other stakeholders. This dialogue was already going on in relation to 2 earlier factory fires in the region, and it paved the way for a quick conclusion of the joint statement on building and fire safety. This accord urged the buyers to stay in Bangladesh while measures could be taken to inspect all the ready-made garment factories for structural, electrical, and fire safety, and to strengthen the inspection regime. With between 3.5 and 4 million people employed in the sector in Bangladesh, 80% of them women, keeping jobs in the country was critical to its approach to development. The accord eventually brought in more partners, including 220 brands, Bangladeshi trade unions, and 4 international NGOs. It was unprecedented due to its legally binding nature and committing brands to pay into a central inspection regime while maintaining purchasing volumes from Bangladesh, and because of the number of players involved. When the original agreement expired in May of 2018, a transition accord extended operations until functions that were carried out can be taken over by a national remediation structure. While the accord has been termed a paradigm shift in the sector, there are now some concerns that the accord might lose its license to continue operating in Bangladesh. The ILO Secretariat has acted as the neutral and independent chair of the Accord's steering committee, and it advises on relevant international labor standards and their application. Inspection training has built local capacity. By October 2018, thousands of factory inspections had been done, with a 90% rate of remediation of problems and the resolution of multiple complaints. Factories that are found to pose immediate harm to workers' health are ordered to be closed. The Accord provides for dispute resolution mechanisms that include anonymous safety complaints, time-bound mediation, and the option of appointment of a court of arbitration in line with international rules. To date, 2 important cases arising from the Rana Plaza tragedy have been reported as settled through confidential arbitration under the Accord, some of them involving millions of dollars. The alliance the full name is the North American Alliance for Bangladesh Worker Safety, involved another 5-year commitment which supported participants to improve building and fire safety. It included provision of loans, inspections, safety training, and remediation, and contributions to the compensation fund. The alliance has been more business-driven than the Accord and has included the essential perspective of how to finance factory rehabilitation. In December 2018, the alliance stopped its work, pointing to what it had already done. Most of the 29 alliance members, the brands involved, now plan to work through a locally based organization to collectively monitor safety in the sourcing factories. The third main element has been the arrangement, and this involves another aspect. The Rana Plaza disaster laid bare the country's lack of an effective mechanism to provide compensation for dependents of workers who were killed and for survivors needing long-term medical care. The arrangement ensured a single approach to victim compensation that relied on an ILO convention, the ILO's Employment Injury Benefits Convention, even though it was not ratified by Bangladesh. The principles in it helped structure a bridging solution to provide compensation to the victims under a multi-stakeholder coordination committee that was also chaired by the ILO. The group fixed methods for benefit calculation and distribution. It set up an expert claims administration and designated local legal NGOs to provide pre-claims counseling and assistance to victims. At the party's request, the ILO set up the independent Rana Plaza Trust Fund to receive third-party donations, principally through the Accord and the Alliance. Victims who were left injured or traumatized received training, counseling, and medical support. Now there is a move to create a new national employment injury insurance scheme to provide an enduring solution. The methodology developed for victim compensation under the arrangement has since been used elsewhere. Another major element to mention is the development of the ready-made garment and better work programs. In September 2013, the ILO, with support from Canada, the Netherlands, and the United Kingdom, launched something called the Improving Working Conditions in the Ready-Made Garment Sector program. And you here have an excerpt from a booklet that describes this program. And if you go into it, you can click on the QR code or the video, and you have explanations with graphics and so forth, people's interviews, explaining in more detail how the various aspects of this program work. A major focus has been on remediation, with much accomplished by support to the Accord and the Alliance. Involving a range of stakeholders, the initiative also entails collaboration between the ILO and the International Finance Corporation, which together have developed better work programs in other countries. The project seeks to promote competitiveness in the garment industry by incentivizing compliance with international labor standards and overcoming obstacles to the financing of remediation efforts. The program includes law reform, with one challenge being how to reach the many millions of workers in informal working arrangements who are also a link in global production chains. The ILO supervisory machinery has continued to call for law reform in Bangladesh to address serious shortcomings, in particular relating to labor inspection and freedom of association, and both relate very closely to ensuring workplace safety and health. The ILO's roles as convener, neutral broker, trustee, and expert advisor in response to Rana Plaza, working with partners, have legitimated the institution's value. However, current ILO resource levels would not permit replication of a response on this scale in many more of its other 186 member states, 187 in total. All the same, the Better Work program can be extended, and experience under the arrangement could guide an orderly and fair handling of future compensation claims, which we hope would not be necessary, but probably will be. Reactions to the Rana Plaza disaster confirm that companies sourcing globally run high risks in industries that do not take worker safety and environmental protection seriously. Although so far none of the court actions brought by survivors or heirs has concluded, such lawsuits have put pressure on firms worried about reputational as well as legal risk. But for victims, litigation is a slow and expensive option, facing high hurdles: jurisdiction, choice of law, time limitations, enforcement of foreign judgments, and more. And even the criminal charges that were filed against the Rana Plaza owners and others have not yet led to convictions. These experiences explain, in part, why other avenues are being pursued. We'll now take a look at some of those. The sheer dimension of the Bangladesh disaster also spurred developments in a number of other CSR-related processes that were already in place or planned. We can only skip over them here, but they illustrate how complementary leveraging by labor and consumption power led to post-Rana Plaza responses, and those same forces promise to influence these efforts in the years to come. The first of these is the UN Guiding Principles on Business and Human Rights, which was adopted in 2011 by the United Nations Human Rights Council. The UNGPs have really emerged as the dominant framework for CSR, using what is known as the Protect, Respect, and Remedy framework. The labor rights dimension of the UNGPs derives from their reference to the ILO Declaration on Fundamental Principles and Rights at Work, the Universal Declaration of Human Rights, and the UN covenants, in particular the one on economic, social, and cultural rights. The UNGPs address the state's role in protecting and fulfilling human rights, businesses' role in respecting human rights, and the need to match rights and obligations to appropriate and effective remedies in case of breach. As part of their responsibilities, firms have a duty to engage in due diligence and to cooperate in remediation where they have caused or contributed to adverse human rights impacts. The strength of the UNGPs lay in the broad consensus they attracted and their use of a management process, due diligence, that spoke to business in its own language. Yet firms and human rights labor activists may hear that term differently and ascribe different meanings to it. In the labor rights context, due diligence can imply a substantial investment if taken in earnest, as I have explored in a book chapter mentioned in the publication to which Adele referred, the Research Handbook on Transnational Labor Law, which she modestly forgot to mention was co-edited by her. Critics have pointed to some inconsistency and vagueness in the UNGPs, especially when they relate to accountability along value chains. All the same, the UNGPs set a framework for other developments and have driven business involvement vis-à-vis the UN's Sustainable Development Goals, to which we will return a bit later. 4 other post-Rana Plaza processes also merit mention. Those related to the UN Working Group on Business and Human Rights, the emergence of national action plans, some crossover with OECD national contact points, and calls for a binding instrument on business and human rights. The paper went into those, so I'll just highlight a few points here. The UN Working Group on Business and Human Rights has made recommendations for enhancing access to effective remedies and convenes an annual forum where new practices are shared. One noteworthy example of that is the 2017 law in France on the duty of care, known as the Loi de Vigilance, that requires large firms to publish and implement a due diligence plan aimed at environmental and human rights risk identification and responsibilization along the entire value chain. The working group has also issued guidance on national action plans, which are evolving policy strategies with active civil society engagement. This guidance calls on states to ratify relevant ILO conventions and address gaps in legal frameworks. It recommends steps to ensure that parent companies can be held legally accountable for adverse human rights impacts caused by other members of the enterprise under their control. Under Guiding Principle 26 on reducing legal, practical, and other barriers to access to remedies, the UN Working Group encourages governments to consider providing national labor tribunals with the competency to adjudicate business and human rights impacts. It is very unclear, however, how they would be able to deal with complex tort or commercial litigation. Nor is there any reference to labor arbitration or mediation, grievance mechanisms under collective bargaining agreements, or to international framework agreements as possible avenues for access to effective remedies. At the same time, the Accountability and Remedy Project of the Office of the UN High Commissioner for Human Rights is currently looking at non-state-based grievance mechanisms. So far, no mention has been made of relevant ILO instruments, but the comment period is still open. Outside the UN, some convergence has occurred between the UNGPs and examination of complaints by OECD contact points under the 1976 Guidelines on Multinational Enterprises. In Denmark, the National Contact Point found in favor of a complaint alleging that the owner of a menswear chain had violated the OECD guidelines by failing to carry out due diligence on its supplier and by not paying compensation to the Rana Plaza Donors Trust Fund. The NCP made a number of recommendations for the firm to use risk and decision-making systems in connection with inspections and supplier visits, and to ensure employees' basic human and labor rights. Then last year, the OECD issued due diligence guidance for all multinational firms. Perhaps the current key to still greater coherence in this field lies with the Sustainable Development Goals. The business community was among those shaping the SDGs, which the UN General Assembly endorsed in 2015 for attainment by 2030. The SDGs link and deepen the three pillars of sustainability: economic, environmental, and social. Because each goal has targets and indicators for regular monitoring, the SDG process may open up new paths towards greater accountability of firms. Several of the goals could come into play here, and we can look briefly at two in particular. Goal 8, which is on decent work and economic growth, including promoting labor rights and safe and secure working environments, under Target 8.8, and Goal 12, ensuring sustainable consumption and production patterns, such as in public procurement, and by company adoption of sustainable practices and reporting on them, under Target 12.6. The coherence-seeking SDG momentum may help bridge the divide that has so far marked international environmental and labor law. Improving efficiency through innovation, worker safety, and environmental protection go hand in hand. This approach meshes well with a trend towards what is called a sustainability business strategy. In this vein, a new initiative co-funded by the EU, the ILO, and the OECD in 6 Asian countries aims at promoting responsible business conduct in sector-specific supply chains with respect for both international labor standards and environmental sustainability. The UN Working Group has stressed that unless business contributions to achieving the SDGs are based on accountability and respect for human rights, the private sector risks undermining rather than supporting sustainable development. This will imply tackling certain assumptions that are made in traditional approaches in the law governing trade, direct foreign investment, and public procurement. The soft law processes described so far here share a common feature: lack of sanctions or enforceable remedies in case of noncompliance. Yet the voluntary nature of the UNGPs was one of the main reasons for their wide embrace. However, many organizations, a number of academics, and some governments remain highly skeptical about whether the soft law approach is sufficient. In June 2014, a contested process began in the UN Human Rights Council, which tasked an open-ended intergovernmental working group with elaborating an internationally legally binding instrument on transnational corporations and other business enterprises with respect to human rights. This is known as the treaty process. Proponents have moved ahead in the face of substantial opposition from many governments and the business community. Following contentious consultations, the open-ended working group released the first official draft of a legally binding instrument in July of 2018. In its first 7 articles, this zero draft, as it's known, lays out the purpose. It defines victims and business activities of a transnational character. It sets out bases of jurisdiction for legal actions, constrains statutes of limitations, and contains provisions on applicable law. One draft article lists the rights of victims, including the right to fair, effective, and prompt access to justice, information, legal assistance financed through an international fund, and effective mechanisms for the enforcement of remedies. On prevention, the draft specifies due diligence requirements, including throughout the supply chain. It says that failure in this regard shall result in commensurate liability and compensation. Under the draft, states are to ensure through their domestic law that their natural and legal persons over which they have jurisdiction may be held liable, and there are sections on civil and criminal liability and on protection of human rights defenders. The draft foresees mutual legal assistance and international cooperation. It takes a rather conservative stance in relation to existing international and domestic law. At the same time, it seeks to restrict the interpretation of existing trade and investment agreements, as well as future international agreements. Finally, the zero draft puts forward institutional arrangements that include a classic human rights expert committee. The working group has also put forward a draft optional protocol under which a state would need to designate or establish a national implementation mechanism. This would promote compliance with human rights in the business context, monitor and implement the proposed legally binding instrument. The optional protocol would also permit examination of individual and collective communications that allege violations. The open-ended working group is now to prepare a revised version of the draft treaty for discussion in October of this year. In the meantime, the hundreds, literally hundreds, of civil society organizations which form the Treaty Alliance, as well as the more cautious voices from the Business and Human Rights Center, which is led by John Ruggie, who was the UN Special Representative on Business and Human Rights, spar over the drafts on social media. Indeed, there are a lot of questions and a lot of proposals that leave many issues in the air. One wonders in some cases where there perhaps might be a bit of a need for a reality check. That being said, the Zero draft was a much more classic version of an instrument that initially, in its draft elements, had contained a much wider-ranging set of provisions. The proponents of the new treaty see it as complementary to a higher and more nuanced notion of CSR, and on the implementation of genuine protection and remedy for victims. Some opponents claim that the move towards a binding instrument betrays the global consensus that was reached with the adoption of the voluntary UNGPs. Others fear that such a treaty could hinder or weaken existing guarantees in other instruments and their natural evolution. In any case, the treaty process remains a captive to its statist model. You might recall that it has this provision that makes a renvoi to other international and domestic law. One could ask whether countries that fail to respect existing labor rights instruments would do better under a new one that calls for remedying their violation. That being said, the momentum behind the treaty process is quite strong. The negotiations leading up to a possible treaty take place against a backdrop of long-running debate over the relationship between hard and soft law instruments and between regulation and self-regulation in the area of occupational safety and health. The independent ILO Committee of Experts on the Application of Conventions and Recommendations takes the view that while new forms of private compliance and innovative mechanisms are to be welcomed, such strategies cannot replace the compliance and enforcement functions undertaken by independent and specially trained public servants. With so much attention given to the UNGPs and the treaty process, it is easy to overlook developments in other areas that may affect the ability to vindicate workers' rights in global value chains. One example is the new industry standard, ISO 45001, which was adopted by the Non-Governmental International Organization of Standardization over opposition by ILO employer and worker organizations. The group's rejection of ILO proposals will probably reinforce an industry-led approach to occupational safety and health that favors self-regulation and minimizes the role that trade unions and collective bargaining can play in supporting OSH measures on the shop floor. Such developments lend some credence to critiques that there is a de-emphasis on redistributive rights of workers and preference for individual over collective rights, a question we can debate in the question period. So summing up, to what extent can the lessons of post-Rana Plaza be extrapolated to other sectors? Skeptics argue that the persistence of unfair labor practices into the 21st century is a structural problem for which responsibility lies not only with all actors, but also with the underlying political and institutional structures. So far, ethical supply chain management has largely focused on big companies whose competitive advantage is associated with brand image, and which also often relies on extremely low wages and long working hours. This segment represents only the segment of the supply chain management, represents only a small part of a much bigger picture. Seeing that bigger picture has recently led the Global Commission on the Future of Work, that was convened by the ILO, to urge adoption of a universal labor guarantee that would include safe and healthy workplaces, an adequate living wage and limits on working hours, along with respect for fundamental rights at work. The challenge will be how to move this from a declaration to something more concrete. In the post-Rana Plaza world, we see action on many fronts, but the search for effective means to prevent industrial disasters and for remedial measures in case of loss of life continues. Global value chains are gender-skewed, and the solutions will need to be gender-sensitive as well as sector-sensitive. And until business models and consumption patterns change, the measures to date will not be sufficient. Nevertheless, the responses to the Rana Plaza disaster have advanced transnational labor law by moving it on to new terrain. The experience has shown that the ILO can act swiftly and creatively within its given mandate, drawing on the strengths of its tradition in promoting dialogue, international labor standards, and capacity building on the ground. In partnership with other actors, the ILO played on its universal strengths by offering a single avenue rather than scattered approaches to finding solutions in response to employer and worker demand. There are new calls for bolder action by the ILO to promote respect for international labor standards in global value chains. One idea would be equipping the ILO to inspect, mediate, advise on remediation, and administer claims in the case of industrial disasters, or any of those alone. Drawing on its standards, the ILO could set protocols for certifying experts to take out certain tasks, thus giving a more credible alternative to what ISA will probably have on offer. Of course, the prospects for success for any such ideas will depend on the willingness of ILO constituents to create such space, and of governments to act more coherently around environmental, economic, and social issues that occur in different fora. It is time to move from thinking of social justice as a distant goal to finding new mechanisms to arrive at prevention of disasters, and when this fails, to ensure effective remedies for victims. Respect for rights relating to occupational safety and health go hand in hand with showing greater care for the external environment. There is a strong case for the adoption of a new development model that accounts for social, environmental, and economic outcomes simultaneously. The Global Commission on the Future of Work thus urged adoption of a new indicator that would capture the externalities of economic activity, notably the resulting cleanup and healthcare costs of disasters. With firms increasingly aware that prevention is in their own long-term interest, there may be further progression from voluntary corporate social responsibility to real accountability. For as Kofi Annan sagely reminded us, there is no planet B. Thank you.
Thank you very much, Anne Treblecock, for comments that are at once informative, insightful, and measured. It is now my pleasure to introduce to you our second speaker, Professor Poonam Puri, who is Professor of Law at Osgoode Hall Law School and is one of Canada's most respected scholars and commentators on issues of corporate governance, corporate law, and securities regulation. Professor Puri earned an LLB degree from the University of Toronto and a master's in law from Harvard. She then went on to be appointed at York University's Osgoode Hall Law School in 1997 at the age of 25. And she won Teaching Excellence Awards twice, 99, 2009. She's prolific. She's authored nearly 100 books, book chapters, scholarly articles, reports in leading Canadian and international journals. She's been awarded multiple grants to conduct research on capital market enforcement, auditor liability, the Equator Principles, and environmental sustainability. Governments, regulators in Canada and internationally, including the Ministry of Finance, the Ontario Securities Commission, the Law Commission of Ontario, the Canadian Foundation for the Advancement of Investor Rights, and the International Financial Corporation of the World Bank, continue to seek out her expertise. Professor Puri is also a seasoned corporate director, and she currently serves as a director of Canada Infrastructure Bank and Holland Bloomview Kids Rehabilitation Hospital. And in 2018, she was appointed as a commissioner of the Ontario Securities Commission. And in the past, she has served on a variety of boards, from the Toronto Airport Authority to the Women's College Hospital. I want to underscore that in 2017, she founded Canada's first ever investor protection clinic and a living lab at Osgood. It provides pro bono legal advice to investors who believe they've suffered an investment loss as a result of someone else's wrongdoing. Professor Puri has presented widely, over 200 invited conferences and workshops to a wide range of audiences. She's delivered TEDx talks on Canadian financial crisis and accountability of multinational corporations. And she's a regular print, radio, and TV media commentator, and she has earned many honors. Let me just mention that she was selected twice, 2015, 2017, as one of the top 25 most influential lawyers in Canada by Canadian Lawyer magazine. Finally, let me underscore the fact that Professor Puri is a member of the 2016 cohort of the Pierre-Elliott-Trudeau Foundation Fellow. And her presentation today builds from her fellowship project entitled Piercing the Corporate Veil. It's aimed at developing creative policy and legal solutions to holding multinational corporations more accountable for their actions globally when they cause harm to individuals and communities. And it offers an opportunities for, frankly, a most fitting conversation between corporate law experts and those whose focus has been on more traditional domains in transnational labor law. So thank you very much, Professor Puri, for accepting this invitation to participate and to present. And the title of Professor Puri's talk is The Rana Plaza Tragedy: Reflections on the Future of Multilateral Corporate Accountability.
Thank you very much, Professor Blackett. I'm delighted to be here with this distinguished panel and with all of you today. And what I'd like to do over the next 30 minutes or so is talk about the Rana Plaza case, which I asked all of the students to review, and I asked you to read the Court of Appeal decision. The trial decision was 300 pages long, and you're welcome to read it, but I thought the Court of Appeal decision would be really useful for our purposes. And so I want to talk about the decision and the results. You've already heard from Anne Trebilcock about some of the facts, and from Professor Blackett as well, so I won't repeat them in detail. So I'd like to talk about that case. I'd also like to talk about a number of other legal proceedings that are making their way through the Canadian courts, and particularly in reference to Professor Blackett's comment about my larger project, looking at other companies, particularly in the context of Canadian parent companies with subsidiaries operating abroad, and the cases that are working their way through the courts that initially, as I was analyzing the cases, seemed to suggest a bit more promise, and we'll talk more about that. And then getting to the Rana Plaza case in terms of the actual decision on the merits and the decision of the Court of Appeal that affirms Justice Perel's decision. So over the next 30 minutes or so, and then throughout the afternoon, really focus in on the responsibility, the obligations, of multinational corporations, Canadian multinational corporations. Again, initially my Trudeau project was focused more so on extractive industries, but then I also recognized as I was doing my research and analyzing cases that this is obviously an important issue in the manufacturing context as well, and we'll talk again about Rana Plaza in that context. And globally, there are many, while I'm looking at Canadian cases, globally there are many legal proceedings going on around the world, not just in mining and natural resources, but in manufacturing and chemicals, in textiles, in agriculture, food, beverage, again, not just in Canada, but around the world. And so one of the big issues in my project is looking at, well, what are some of the challenges when those who have been harmed are trying to use domestic courts, domestic remedies, domestic substantive law, whether it's corporate law, whether it's tort law. What are some of the challenges? What are some of the hurdles, and what are some of the roadblocks? And with the Rana Plaza case, you see what some of the roadblocks are. And with some of the other legal proceedings, again, we'll talk about some of the roadblocks and how one might be able to get around them, or one, they really might be dead ends. And so in that context, to the extent that using legal proceedings, using litigating cases may or may not be effective, what other options are available? And so thinking then outside of the cases, I'd like to get to by the end of our conversation, what other options are available? So what's the role of the common law? Where does it have some possibilities? Where are its limits? And then what are the other options, including legislation? And what are the benefits and value of legislation? Where might it not achieve what the objectives are intended to be? And then what else is out there in terms of boards and senior management of companies themselves acting and behaving responsibly? What about consumers? What about investors, retail investors and institutional investors? What sort of a role can they play? So that's a bit of a roadmap in terms of where I'd like to go over the next few minutes. I'd like to take a few steps back and a few steps sideways before we talk about the Rana Plaza case. When I think about a business, I think about many stakeholders that have an interest in the business. I think about many stakeholders that have something at risk in relation to the business. I think about many stakeholders who will do well if the business does well. Can you think of stakeholders that are related, that are important to the business? What stakeholder comes to mind? What's the first stakeholder that comes to mind for any of you out there? Shareholders. And why shareholders? Why do they come to mind for you? Okay, so they have a pecuniary interest in the business doing well. They've invested financial capital and they want to see a good return, a great return. Okay, so that's great, and I think shareholders will be top of mind for many people. Other stakeholders that have an interest in the business? Workers, so employees, workers, and what's their interest in the business?
A job.
They want a job. They are investing their human capital, their talent, their time, and they want to see the business survive, thrive, do well, because this is their livelihood and this is what they have decided to do. Others?
Depending on where the business operates, the local peoples or Indigenous peoples might be interested in the impact of the operation of the business.
Okay, so local communities, Indigenous or otherwise, may be interested, or likely interested in how the business does and the impact that the business has on the local community. So if it's a manufacturing plant, that might be relevant. If it's a mine, that might be relevant in a different way. Headquarters might be relevant in a different way, absolutely. So we've got employees, we've got the local community, we've got shareholders. Any other? Yep.
Creditors?
Creditors, and why so creditors?
Well, they will have made like shareholders, they will have made an investment that they particularly want to see recouped, and so the fate of the business is tied into their interest directly.
Okay, so creditors have also made they've made some sort of a financial investment directly or indirectly. They might have provided financial capital, they might have provided supplies or services, and they want to be paid, they want the business to do well. Absolutely. Other stakeholders that I have on my notes, consumers, in terms of obviously wanting good quality products at reasonable prices, whatever that means in different contexts. As well, I have down directors and managers, those who run the corporation on behalf of whether we decide it's the shareholders or all the stakeholders. So those who run the corporation, those who are elected, the directors are elected by the shareholders to run the corporation and then delegate those powers or many of those powers to the managers. So lots and lots of stakeholder groups that are out there that have an interest in how the business does. What's interesting in the corporate law framework is that there's very much an emphasis on the rights of shareholders. So it's very much about the rights of shareholders and the responsibilities of directors and officers to the corporation and also to shareholders. So when you look at your corporate law statute in the Canadian context, it's very much about that. There's very little in the corporate law statute itself that deals with employees or that deals with creditors. I can think of a few provisions that deal with creditors when the company is on the brink of insolvency. There's one provision that I know of that deals with employees, again, when the company is on the brink of insolvency, but there's no mention of consumers. There's no mention of local communities. There's no mention of government or the environment. So it's silent on that. And so what does corporate law legislation say about protecting these stakeholder groups? It says look elsewhere. So for consumers, it says look to the Consumer Protection Act, look to contract law, which of course will depend on what the playing field looks like. For employees, it says don't look to the corporate law statute, look to collective bargaining if there's a union or the possibility of it. Look to employment standards. Look to contract law, look to private ordering, but don't look to corporate law. So when you look at the legislation, it's very much shareholder focused, and so, okay, you think that's fine if that's the premise and you're supposed to look elsewhere, you kind of know the rules of the game. Then I look at one provision in the corporate law statute which focuses on directors' fiduciary duties, and it says directors have a duty to act in the best interests of the corporation. And that's it. So a big general principle, but what does that actually mean? And so we rely on the courts to interpret that provision, and I will take you back 10, 11 years to a significant Supreme Court of Canada decision that came out of this province, in fact, the BCE decision, BC versus 1976 bondholders. So in 2008, very briefly, Bell Canada Enterprises, one of the largest telecommunication companies in Canada, was trying to figure out how to really survive, how to think about the future. Its stock price was relatively low compared to its competitors, and it was looking to make a change given that its shareholders in particular were demanding that change. The board looked at all sorts of options. At the time, it considered an income trust, it considered all sorts of other transactions, and the transaction that it decided to move forward with was a leveraged buyout. And it decided to do it in the context of an auction. So we're going to put our company up for sale. There were 3 bidders, and it chose the bidder and the package that it thought was best for the best interest of the corporation. So what was this bid all about? Well, this bid would have resulted in a 40% premium to the shareholders over the market price of the shares at the time, but it would have resulted in a 20% drop in value for the bondholders. So there were a certain group of bondholders that were really upset about this. Understandably, their market price of their bonds had gone down by 20%. Meanwhile, the shareholders are benefiting significantly from this. So in the context of the court approval for this transaction, the bondholders went to court and said, this transaction is not fair and reasonable. You should not approve it. It's not fair and reasonable. Even though the shareholders have overwhelmingly approved it by 98% or so, the court should not approve it. And they said, and this transaction, what the directors have done here is oppressive. So they also launched an oppression action and said that, everything the company did, everything that the company released said that they would maintain the investment grade on our bonds, that they wouldn't do anything to jeopardize the value of our bonds. And look now, we're going down by 20%. So what did the court say here? The court said, look, there's no duty, this is the Supreme Court of Canada, there's no duty that the directors owe in interpreting the best interests of the corporation. It's not the best interests of the shareholders. It's not the best interests of the bondholders, who would be a type of creditor. It's not any particular stakeholder group that this fiduciary duty is owed to. It's the best interests of the corporation is the corporation itself. And what does that mean? Well, the directors can consider the interests of different stakeholder groups, be that shareholders, employees, customers, whichever stakeholder groups are affected. Directors have an obligation to think about their interests. They could think about them, discuss them, give them really low priority, give them high priority. They could reject that interest, but the obligation is to consider their interest. The obligation is not to do what their interests demand or do what they are insisting that you do. So that's the first point that the court says. The second point is, as long as the directors, the board, follows a really good process, courts are going to take a hands-off approach. So as long as there's no conflict, the directors are acting in good faith, and they're following a diligent process, they're really kind of discussing the issues at hand, the court is going to respect that decision, because courts are not here to second guess directors. Directors have been elected, they are business people, the judges are not going to step into their shoes. So that's a concept known as the business judgment rule. And then the third comment that the court makes is that we're going to let the directors act in the best interest of the corporation, but then it gets into language about being a good corporate citizen. So we're not going to tell you what to do, directors, in terms of shareholders first or second or third, where do employees rank in this, where do customers rank in this, but the corporation should be acting as a good corporate citizen and treating all stakeholders fairly. So that language I pull out in this context, and I think it's important for us to have on the table. And so what do I take away from the BCE decision? That it gives a lot of discretion and responsibility to corporations. It gives a lot of discretion and responsibility to directors who are at the kind of the top of the corporate organization. And particularly in a context where corporations in our economy and in our governmental structure make so many significant economic decisions. What to produce, how to produce it, where to produce it, what price to sell it at, what quality, is it going to be through a subsidiary, is it going to be through a contracting relationship? No one is telling the corporation how to do that. They're deciding these things themselves. And so I think all of those points, again, are relevant and important in terms of the context when we're thinking about some of these decisions and some of these situations where then harm occurs, and we're trying to figure out how should the losses be allocated. Does it sit with the people who are suffering that harm, or does it need to be reallocated in a way that would appear to be fairer? So now let's turn to kind of step 3. So step 1, from my perspective, was laying out the range of stakeholders that are involved in a business. Step 2 was talking about the BC decision, and it's kind of just 11 years old, but I think significant. And now I look at a number of cases in the Canadian context which focus on veil piercing. And before we can talk about veil piercing, we have to talk about the fundamental corporate law principle that shareholders have limited liability for the obligations of the corporation. So as a shareholder, if I invest $100 in a company, I may lose that $100, but I'm not responsible, unless I've agreed to it somehow, I'm not responsible for any other losses of the corporation, or if the corporation's responsible to a creditor or an employee, I as a shareholder am generally not responsible. And so we've got this principle of limited liability, and we've got this principle of a corporation as a separate legal entity from the shareholders that invest in it. And this concept is relevant not only if I'm a shareholder as an individual, but also in the parent subsidiary context. So a parent corporation that owns 100% or 50% of a corporation is a separate legal entity from that subsidiary, and in law is not responsible, again, under corporate law principles, is not responsible responsible for the liabilities or the obligations of the subsidiary. What we have developed over hundreds of years is the common law doctrine of piercing the corporate veil. The challenge with the piercing the corporate veil doctrine is that it's a really high standard to meet. Not only does there need to be total domination, total control by the parent over the subsidiary, there also needs to be fraudulent conduct. And fraudulent conduct, of course, is really hard to establish. So now, some of the cases that I'd like to talk about too, I think I'll talk about in terms of the time that I have. Hudbay is one of them, and let's talk about that for a moment. Let me just turn to it. So this is a matter where a group of Indigenous plaintiffs brought 3 separate actions against Canadian mining company Hudbay and its wholly controlled subsidiaries based in Guatemala, alleging that the security staff that were retained by Hudbay's subsidiaries committed human rights abuses, including shootings, killings, and gang rapes of women at the company's Phoenix mine site in Guatemala. In their claim, the plaintiffs asserted that Hudbay retained considerable direct responsibility over key aspects of the subsidiary's operations, as well as key aspects of the security detail and the policies around security. Moreover, in the claim, the plaintiffs note that Hudbay developed detailed standards of practice. So Hudbay, as the parent, developed detailed standards of practice which it imposed on its subsidiaries, and that Hudbay also voluntarily committed itself and its subsidiaries to complying with international law. And the arguments the plaintiffs say is all relevant in terms of their claims. One, to pierce the corporate veil as between the parent and the subsidiary corporations, so that the parent company is responsible. And 2, also they made an argument in tort law that Hudbay, the parent company, has a direct duty of care and then breached that duty of care to the plaintiffs in Guatemala. So not only a veil-piercing argument, which is an indirect argument, but also a tort law argument. Now, Hudbay, the company, and as often happens in many of these cases, brought a motion to strike the plaintiff's claim for disclosing no reasonable cause of action. And they just said, well, look, veil-piercing can't happen here under corporate law because there's no fraudulent conduct. We can't be responsible for our subsidiaries' actions. And under the tort law argument, there's just no chance this is going to succeed. So what did the court say here? So again, the court's decision was not a decision on the merits of the case. This was an early motion, and the court has to decide, is it going to let this case proceed to the merits, or is it going to shut it down early? And with respect to the first claim, in terms of the veil-piercing claim, the Superior Court in Ontario affirmed corporate law principles and said the court, courts are not going to veil-pierce if the subsidiary corporation isn't used for a fraudulent or an illegal purpose. Thank you. In terms of the prongs to pierce the veil, there's the common law doctrine of veil-piercing, and you need to have fraud. They'll also veil-pierce if, judges will also veil-pierce if it's in the statute. And there are certain statutes where it is clear, or it is much clearer, that the parent company can be responsible for the actions of the subsidiary. And I'm thinking environmental law, I'm thinking in some cases employment law, and again, I'm not an expert in employment law, and also as well income tax. So in some other areas of law, we've made policy and legislative decisions to allow for parents to be responsible. Or third, by contract, you might contractually agree for a parent company to be responsible for the actions of the subsidiary or for the debt of the subsidiary using a guarantee, for example. So the court says here, it's going to be highly unlikely that the veil-piercing argument's going to work. We don't really see any fraudulent conduct. Now, in terms of the tort law duty of care claim, Hudbay says this is just not going to go anywhere. Like you need to strike out this this action right now. The court says, well, let's think about the relevant test, and let's think about the relevant test in terms of establishing new tort claims, new duties of care. That was developed by the UK House of Lords in Anne's and Merton Borough, and then it was modified by our Supreme Court in the Kamloops case. And it says, okay, this is a preliminary motion, so we're going to assume that the facts that the plaintiffs have pleaded can be proven at trial, and so let's walk through them. So for a novel duty of care, you need to show that the harm complained of is reasonably foreseeable, and it's a foreseeable consequence of the alleged conduct. 2, that there's sufficient proximity between the parties, such that it wouldn't be unfair or unjust to impose a duty of care. And 3, there's no policy reason to negate or restrict the duty of care. And all of these factors are relevant in the Rana Plaza case as well. And we'll talk about that in a moment. So with respect to the first branch, the court says foreseeability. Well, the court says the harm was foreseeable. Hudbay was aware, or should have been aware, that the human rights abuses are frequently perpetuated by security personnel in Guatemala. They were on alert, or they should have been on alert. And so there's a foreseeable risk. Again, this is early stage, not on the merits, unlike Rana Plaza, which was on the merits. The second piece is there sufficient proximity between Hudbay and the Guatemalan plaintiffs so as to ground a duty of care in tort law? The court says here, well, close causal connection between the parties. We need to look at that. We need to look at the parties' expectations, and we need to look at any obligations that were assumed by Hudbay with respect to the plaintiff. So again, relevant factors for the Rana Plaza case. So to this end, what does the court do here? The court focuses on the fact that Hudbay had made repeated representations about security and the property disputes that were taking place at and near the mines. And to the court's mind, this demonstrated that Hudbay had turned its mind on how best to deal with the ongoing issues with the Guatemalan natives. And it had also made public statements to this effect. As well, the court notes that Hudbay had assumed direct responsibility for these issues. It had formulated corporate responses. This is the parent company in response to the claims by the Guatemalan indigenous peoples. It also exercised supervisory authority over the employees and agents who were in Guatemala on behalf of Hudbay and the subsidiary. And so based on all this evidence, the court said, well, there's enough here, if it's proven at trial, that this could potentially draw Hudbay into a relationship of proximity with the plaintiffs. And I think important here is the Justice Brown said, look, the plaintiffs here, or the defendants here, have brought themselves into proximity with the plaintiffs. It's not just that this sort of a relationship will always be a proximate relationship. It's going to depend on the facts, and it's going to depend on the facts of each case. So not all parent companies are going to be in a proximate relationship with individuals or groups of people that are harmed by a subsidiary or someone else. So important point again, because it's all going to depend on the facts. And then finally, what are the policy reasons favoring a new duty? What are the policy reasons that negate against a new duty? So what do the parties say here? The defendants say, well, look, there have been all sorts of legislative attempts to try and regulate in this area, particularly extractive industries and with relation to human rights, and impose additional responsibility on them, and they've all failed. And so why are you, the courts, getting involved here? And that you're just going to kind of mess up what the federal government is trying to do. The plaintiffs, on the other hand, said, well, this is actually going to assist our kind of corporate social responsibility framework to the extent that legislatures haven't been able to move forward on this. Here's an opportunity for the court to do so. So the court here says there's enough of a policy basis for the matter to proceed to trial. The court did not weigh the policy considerations in this particular case, because again, it wasn't on the merits. It was at an early stage whether the case should be kicked out or should it be allowed to move forward. And so It's moving forward. It hasn't, we're waiting for the trial. We're waiting to hear the case on the merits, and I think it'll be important to follow this case and see what happens. And now I realize that I only have 5 minutes left, so I'm only going to talk about the Hud Bay case, and I think it's an important one. I'm going to highlight the Nevson case, which was just heard by the Supreme Court of Canada, that I think all of you should follow as well. And let's now turn then to, and a third case, which again I won't talk about, is the Chevron case. Different, it's not about the substantive merits, but it's about collecting on a judgment that has been received. And again, it ties in with the big idea of can you collect from a subsidiary, even though the subsidiary wasn't the one responsible, wasn't involved in the initial action? Can you think about the corporation and its subsidiaries as one large enterprise, or do we need to continue to treat them as separate entities? So now, where are we with the Loblaws and Rana Plaza case? So in the Loblaws case, Loblaws had a contract with Pearl Global, and I'm basing this all on the decisions that I've read, as you have. And then Pearl Global had further subcontract relationships with New Wave, with two New Wave companies. Loblaws had a vendor-buyer agreement that incorporated all sorts of provisions in terms of its CSR standards and its supplier provisions, which required it by way of the contract that the contractor, the manufacturer, would comply with local and national laws and adhere to best practices in the industry. No reference in terms of the structural integrity of the buildings in which the manufacturing was taking place, but kind of some general principles in the agreements. And so Loblaws made a decision not to manufacture the clothes themselves through their subsidiary, but to enter into this sort of a contractual relationship. And the other party that's sued in this context is a company that Loblaws engaged to do a social audit, Bureau Veritas. And they did a social audit on health and safety in the premises. They went in 2011 and 2012 and did some audits, but they weren't asked to do any inspection or audit of the structural integrity of the building, though that is something that they offer, but they weren't asked to do it. So now when I read the case and the decision, this is Justice Perel and then Justice Feldman and the Court of Appeal confirming this. I read that the court says whether you apply Ontario law or whether you apply Bangladesh law, and we don't have time at the moment to get into the details, but happy to discuss it if we're interested in the conflict of laws rules, that there's just no chance of success. And so using and they refer to the Hud Bay case, they refer to the Nevson case, but they say those are different. Those are parent-subsidiary contexts. Justice Perel seems to think those cases are more promising. We'll see what happens as those cases are heard on the merits, but Justice Perel is clear that those are very different cases when you have a parent and a subsidiary, as opposed to this context where it's a contractual relationship. So I'd like to ask you during our discussion period, what is the difference between the structuring your organizational affairs through a subsidiary versus structuring them through a contractual relationship? There's a lot of discussion in the case about control. Sure, Loblaws could terminate the contract. Loblaws could arrange for an inspection, but they didn't have control. They didn't have the same prongs of control that you might have in the subsidiary context. So I want to talk more about control as well and what that means to you. There's reference as well to this would be a big jump in the law. This would be a big leap in the law if we were to make responsible a company like Loblaws responsible for the actions of its contractor or its subcontractor. It didn't have control over how they ran their processes. It didn't have control over the employees, but it would be a big jump in the common law. And the common law doesn't work that way. The common law works incrementally and marginally. So I want to hear more from all of you on that. And to the extent that judges, or at least some of these judges, feel that they're not able to provide a remedy in this framework for those who have been injured, then what are other options available? And so I mentioned in the Hudbay case, the failed legislation for the extractive industry was used both by the plaintiff and the defendant to try and argue their points. So what is possibly a role for legislation in this context? And, you know, to Anne Trebilcock's point, would it have to be, or should it be industry specific? How should it take into account gender? So I'd like to talk about that. Also like to think about the role of investors. So do investors care about how products are made, how services are performed, what standards are used? And to the extent they do, then, you know, is more disclosure required? Or should investors insist on more disclosure? Are investors, retail investors like me or you, in a position to insist on that, or does a regulator need to insist that it be included in mandatory disclosure? And then in terms of consumers, ultimately, consumers wield a significant amount of power in terms of what they buy and what their preferences are. And so what's the role of consumers here and groups of consumers? And then finally, going back to boards and the those who run organizations, to the extent that they have so much discretion and so much power and authority according to the corporate law statutory framework we have and the corporate law legal framework as interpreted by judges, then what are our expectations of directors and senior management? And to the extent that we have some say in who ends up being on senior leadership of Canadian companies, what sort of pressure, what sort of pushes and pulls can we insist on there? So with that, I think I will end my formal remarks, and I will very happily take questions and also engage in a discussion with you shortly. Thank you.
Thank you very much, Professor Puri, for a very engaging and topical discussion. J'ai maintenant l'honneur de vous présenter la commentatrice de notre séance, la professeure Isabelle Martin, qui est à la faculté de droit. Elle est professeure agrégée à l'École des relations industrielles. Je ne vais pas le dire. Donc, elle est professeure agrégée à l'École des relations industrielles de l'Université de Montréal. Elle est aussi chercheure du Centre de recherche interuniversitaire sur la mondialisation et le travail. Et ses champs de recherche incluent le droit de travail, aussi la responsabilité sociale des entreprises et la gouvernance d'entreprises. Elle s'intéresse tout particulièrement à l'interaction entre le droit, l'économie, la société dans la régulation de l'entreprise et du travail. Donc, c'est un grand honneur aussi de reconnaître que la professeure Isabelle Martin est diplômée de notre faculté de droit où elle a eu son doctorat en droit. Et elle a eu ses diplômes aussi, son bachelor's en économie de l'Université McGill avant d'avoir étudié au premier cycle et à la maîtrise en droit à l'Université de Montréal. Elle est membre du barreau du Québec depuis 1999 et ses publications sur les questions mentionnées sur le droit transnational du travail aussi ont un impact important sur l'évolution du domaine du droit transnational du travail. Donc, merci infiniment, professeur Martin, pour votre présence ici et pour les commentaires que vous allez nous livrer.
Merci beaucoup, Adèle. Merci de l'invitation. Merci d'être là et de m'avoir donné le plaisir de lire avant vous tous les papers qui allaient être présentés aujourd'hui. Et pour moi, c'est un honneur et un bonheur d'être ici. Alors, la plupart de mes commentaires vont être en anglais parce que j'ai tout écouté en anglais et ça serait difficile pour moi de ne parler que français maintenant. Mais je voudrais juste ajouter quelque chose à la présentation, premièrement, de professeur Puri, qui nous laissait avec la question « Que faire lorsque doit-on distinguer entre les situations où on a des filiales d'entreprises en termes de leur responsabilité ou lorsque, comme dans le cas de la Plaza, on a des co-contractants? » Et j'ai trouvé ça très intéressant parce que ça m'a rappelé un vieux paper de 1991 de deux professeurs de droit corporatif, professeurs Hensman et Crackman, qui ne sont pas reconnus pour leur pensée très large en matière de responsabilité sociale des entreprises. Ceux qui l'auront lu en conviendront, mais qui se demandaient, est-ce qu'on devrait pouvoir lever le voile corporatif systématiquement? Et ils concluaient, et ça pourrait être intéressant, si vous voulez la référence du papier, je la donnerai, qu'au niveau du droit corporatif, il n'y avait pas vraiment de problème de le faire. Par contre, il disait, au niveau des considérations politiques, le problème, c'est que si on permet la levée du voile corporatif, les entreprises vont se tourner vers d'autres arrangements que les corporations pour faire affaire. Et ces arrangements pourraient être ces cascades de contrats que nous avons. Alors, d'une façon ou d'une autre, si on restreint la responsabilité, enfin, si on accroît la responsabilité sociale des entreprises dans le domaine contractuel, les entreprises vont se réfugier en droit corporatif. Si on s'attaque au droit corporatif, les entreprises vont se réfugier dans le droit contractuel. Et nous avons tout d'un coup un exemple de qu'est-ce que c'est le pouvoir. Le pouvoir, c'est de pouvoir choisir. Ce pouvoir-là, c'est le pouvoir des entreprises multinationales aujourd'hui, qui peuvent choisir l'endroit où elles vont faire affaire, qui peuvent choisir la forme sous laquelle elles vont nouer des liens, qui peuvent choisir leur main-d'œuvre ou leurs robots qui les serviront. Et ce pouvoir doit être mesuré face au pouvoir des travailleurs qui, eux, sont dans un territoire, comme Adèle le fait remarquer au début, qui sont captifs de ce territoire et qui ne peuvent que tenter d'avoir un emploi pour gagner leur vie. Donc, ce serait la première remarque que je ferais. Je pense qu'on voit l'importance et la difficulté du sujet d'essayer de tout saisir, le pouvoir de l'entreprise et comment inventer des façons de le contrer ou de le équilibrer, tout simplement. Il ne s'agit pas de tout jeter par terre nécessairement, mais de donner plus d'équilibre. Alors, on voit dans la présentation, so now I'll switch to English, so we see in the first presentation of Andrew Bilcock how there has been many steps taken for the last 5 years since the Rana Plaza. And there's a vast array of initiatives that have been taken. And they are very interesting and complementary in the same way. They're not just about Bangladesh. There are also some initiatives that are global. They are about the problems in Bangladesh and also about tackling directly the problem caused by the Rana Plaza tragedy, by the arrangement, but also trying to look at the problem, the safety of these buildings. So they bring us at a place where we can see we have done a lot. Many things have been done in the past 5 years. And what has been developed is like the systematic control of working conditions, safety conditions, and the systematic engagement by corporate leaders to have code of conduct, to have monitoring of codes of conduct, and to have a normative basis that is more grounded, more precise. The legal content of what is meant by being socially responsible has been addressed and has been fulfilled by like the United Nations guidance principles. So this is like a more concrete legal meaning. If you're a legal student or professor, you know you like to look at words. We have engagements, we have a wording, so we can say, oh, there's something taking place. But also initiatives on the spot, on the places, with engagement with the workers, with the unions. So at these two sides, there's been a scaling up of what is meant by transnational labor law. And this is huge, because before there was nothing. Before there was nothing, and then there were just like corporate initiatives like codes of conduct were just for corporations, and their content varied from one corporation to another, and there was absolute discretion on how they would be enforced. So we have scaled up, we have come a long way 5 years after. And it takes us to what Professor Puri talked about. How can we enforce that in front of courts? And I would like to, and I think that you've done a great job in 10 minutes that was left to say a bit about the cases. And it would not be possible to have these cases, this duty of care cases about what corporate social responsibility is without what the development in transnational labor law that Anne Trebilcock highlighted before. So we need both, they're complementary. We need to have a more precise content of what it means to have a duty of care to be able to go in front of the courts. But now we are left with the merit of the case. What will happen? What are the policy considerations that the judges will look at? And I want to just highlight what is troubling the judges. And if we look at Justice Pierre-Elliott remarks, at one point he says, one of the things I'm scared of is that Loblaws is like trying to be a good person, a good company, having like these policy, and if we nail Loblaws, what will happen to these initiatives? Nobody will want to take it. And you may find him naive, and you may laugh at him and say like, oh, wow, he doesn't know much. He never went out of his courtroom, maybe. But maybe he read a study by Braden King and Mary Hunter McDonald that shows that firms that are leading with regard to their CSR practices are the ones who get targeted by activists. The firms who have no CSR policy, who have the worst CSR policy record you can look at, they are never targeted. So what kind of enforcement are we going? Like we're going at the good guys. I'm not saying that Loblaws is like a really good guy. I'm just saying that maybe it's better than other corporations. I will not name because I am on a public and recorded. So I am not naming anyone. If you have watched the Nefson case, the audition on Supreme Court, and you can go to the website of the Supreme Court and watch it, you've done great. Very interesting. And we see the justice there. They are concerned. What will happen next if they allow this to pursue? What will happen next? They are no economists. They are no sociologists. They have no idea. But they wonder, 50% of corporations operating in the mining industry are incorporated in Canada. What will happen next if we find Nefson liable? Well, at this stage, if we just allow it to proceed. There are no economists. They have no idea what it will look in the Canadian GNP. Maybe they should not care.
I don't mind. But in the back of their mind, judges are wary they will cause the next economic recession. And the fact that Nevson has just been taken over by a Chinese firm, may or may not process in their decision. I have no idea. So, in 35 seconds, what is the agenda? What is the agenda for research for the next 5 years? First, I think that we should, as researchers, as students, we should have answers to these real concerns that judges have before opening the Pandora box. We should just tell them, okay, it will look like that. Okay? Second, we should not forget the whole question is about power, equalizing the bargaining power of the parties. So the people we should never forget in this, and of course I'm the School of Industrial Relations, so I have to say that, are the workers and the unions, the local unions on the ground. And every initiative is not to be looked at only as, can we enforce this in first world courts? It should also be looked at, does it empower workers on the ground? And Andre Bilcott pointed that the ISO, the new initiative by ISO regarding safety, one of its drawbacks is that by focusing solely on safety, it ignores the freedom of association rights of workers, which is much needed if safety is to have any meaning concrete in the workplace. So that's it. Thank you very much.
Fantastic. Merci beaucoup. We now have some time for questions, and I'm anticipating there are quite a few. Yes, right ahead.
Firstly, thank you all for your presentations. They were so interesting. I have a question for the whole panel. I was wondering, according to you, what role alternative dispute mechanisms such as arbitration can have in business and human rights violations and in providing access to remedy for victims, and more specifically, what law would be applied in an arbitration to bind corporations?
Thank you. Yes.
Thank you again for the presentation. It was really great. During the readings today, I keep coming back to the idea, the question of, if multinational corporations go into developing countries to take advantage of their low labor standards, what incentive do countries have to raise these standards at the expense of business being done in their countries?
Thank you. Yes.
Hi, thank you for the presentation. I have a question for Professor Puri. I'm wondering, what is the role that corporate institutions has here, like corporate law, securities regulation, play in regulating the human rights violation that corporations are conducting abroad? Because my impression is that the institutions that we have using now are from a different legal nature, different from corporate law, and that might affect the enforceability and the results.
Yes.
I'm also wondering, also thank you for your presentations. I'm wondering, what are your thoughts on the efficacy of the different forums where corporate social responsibility is being discussed? For example, you mentioned the Human Rights Council and the different UN bodies that were building different kinds of conventions and treaties. What are your thoughts on where it's being discussed now, and where do you think might be the most effective forum for these kinds of discussions and legislation?
Great. So for yes, okay. One last thing.
Thank you all for your presentations. I just had one question about the zero draft and the possibility of establishing civil liability for foreseeable harm by multinational companies. I was wondering if you felt like that would positively affect access to justice for victims at the national level.
Okay, well, all right. One last question.
So my question is also for Professor Puri. I'm just wondering, how can we incentivize national governments, such as the Bangladesh's government, to take cohesive measures and actually measures that will address the safety of their own people?
Okay, fabulous. So perhaps we can retain the order of presentation for the order of response to the questions, and each speaker should feel free to take about 5 minutes.
You can stay here if you prefer. It's up to you.
I think I'll stand up.
Okay. Yep.
Thank you for those great questions. And thanks to the other presenters for really stimulating thoughts. In relation to the zero draft question, to take them in reverse order, the zero draft has an Article 10 on legal liability, and basically says that the states parties shall ensure through their domestic law that natural legal persons may be held criminally, civil, or administratively liable for violations of human rights undertaken in the context of business activities of transnational character. It specifies that the civil liability will not depend on whether or not there was criminal liability or its equivalent. And it provides that there should be reparation to the victim, compensation, and so forth. And then it says, subject to domestic law, courts asserting jurisdiction under the Convention may require, where needed, reversal of the burden of proof for the purpose of fulfilling the victim's access to justice. Reversal of the burden of proof is a very powerful tool in law to change the outcome of a lawsuit. So I think there is the potential for this to actually move things forward. Whether or not this zero draft will ever, in fact, become law, international law, and how that international law is then expressed within domestic jurisdictions remains to be seen. So we don't know yet, but certainly the potential is there. In relation to which form is the most effective, I think the question really relates to effective in relation to what? What are you trying to achieve? If you're talking about the possibility of a binding instrument, then clearly the open-ended intergovernmental working group is the place where that's occurring. And then once it exited that, it would go to the Human Rights Council. And then ultimately, if it were to become a treaty, would need approval by the UN General Assembly. So we're quite a few steps away from that. Again, I think you have to ask, what is it that you're trying to, what part of the agenda are you trying to push? Are you trying to find common ground with industry? Then you go, more, you might want to go more the global compact route. If you're trying to push the envelope on a binding instrument, you're in the working group, open-ended working group. So I think it kind of relates to what is it you're trying to do. One thing that I think deserves a lot more attention is the different experiences that you see under national contact points under the OECD Multinationals Declaration, because it's clearly a mechanism that's very much influenced by the activity of civil society groups, and they're trying to use those mechanisms as a way to hold actors within their own societies more accountable for actions. In relation to the question of why would a developing country want to improve its labor standards if indeed it's pursuing a development strategy that is based on low-wage work? Well, I think the main argument for that is that in its own long-term interests, it wants to develop. It does not want to become caught in a low-wage, low-productivity, low-educational development trap. So even if you look at the context of Bangladesh, which has very much put its eggs in the basket of the ready-made garment sector. Development economists are looking at that situation and saying, wait, we really should diversify here. Our own economy is very vulnerable because of the strategy that has been pursued to the exclusion of almost anything else. And one of the labor standards that is often cited are the labor standards regarding the abolition of child labor. And very clearly, the higher educational level that can be attained in a country, the greater potential there is for moving up the development scale. And the very raison d'etre of the International Labor Organization, of course, was to raise all boats, was to make sure that you, in order to maintain peace, absence of war, you cannot do that without social justice, and that social justice involves improving the living standards of people everywhere. Now, why that's not happened has very much to do with the trajectory of economic development, of decolonization, of colonization, et cetera. So there's a long history there and numbers of choices that were taken that created kind of a divide between international economic law and international labor law that very much needs to come together again if we're talking about sustainable practices. I think at that point I don't have more time, so I'll stop there. Thank you again for the questions, and I'm sorry if I didn't answer everything.
Thank you, Professor Blackett. So, and thank you for all of the questions. I'll just respond to a few of the points where I think I might have something useful to say. You know, corporate law really, when I look at the corporate law framework in terms of the role of corporate law and securities law, corporate law is very much a self-enforcing statute. There's no activist regulator that's out there pursuing companies, so it really relies on shareholders to pursue civil liability claims relating to another question that was asked. So shareholders, but also there's room for other stakeholders to pursue claims. So the oppression remedy, as some of you might know, allows for creditors and employees and others potentially to pursue a claim, though generally they haven't been very successful. So, you know, corporate law really, I'll say it's really for the shareholders in terms of the remedies, although there are some options available for others. In terms of securities regulation, the main tool that it has in its framework is disclosure, mandatory disclosure. So securities law doesn't generally say to company X, you must do this or you must do that, but it says you must disclose what you do. And to the extent that transparency about operations and transparency about supply chains is important in this context, at least as one part of a strategy, then I think securities law can certainly play a role here. But in terms of enforcing it, and again in terms of civil liability, the strongest claims in this area seem to be from the shareholders, from the investors who aren't necessarily, I mean, sure, they're going to make a claim that they were harmed by inappropriate or inadequate disclosure or about risks and mitigating those risks, or inadequate, living up to fiduciary duties, but it doesn't get to what we've been talking about in much of this class, which is the harm to those people on the ground in terms of the effects of the wrongdoing. So indeed, corporate law and securities law do have their limitations, that's for sure. I think one point that we didn't talk about is the Canadian Ombudsperson for Responsible Enterprise, which you may have talked about earlier in the class, or may in the coming weeks. But in January of last year, the office was set up, and it's responsible for investigating allegations of human rights abuses relating to Canadian corporate activity abroad. The challenge, of course, is it's been a year plus and no one's been appointed to that office. So on the one hand, our concerns with the common law, it's incremental, you can't make these big changes. Legislation, governments have the power to make big changes, but they also need the political will to do that.
Thank you. Okay, Isabel.
Okay.
So thank you very much. We have Emily Painter, the scientific coordinator of the lab, who will say our thank you.
So on behalf of the Labor Law and Development Research Laboratory, the Trudeau Foundation, as well as the Faculty of Law at McGill University, I'd like to thank our guests this week for truly enlightening presentations on corporate social responsibility, for sharing your rich reflections on the need for bolder international as well as domestic approaches to holding corporations accountable. And as a small thank you, if you would be so kind as to accept these gifts. Just a small token of our appreciation for having you join us today during this lecture. Thank you very much.
And with that, we'll pause. There's a coffee break outside. Students enrolled in the course are invited to return after the break for our closed session. And to our other guests, thank you very much for joining us, and we look forward to seeing you next week.